Good evening. This is Reddy. Every Tuesday, we bring in immigration updates. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Yeah, today we want to talk about more companies seem to be selling employment letters for people on OPT so that they can avoid the unemployment limit, as well as providing signatures on I-983 training plans so that people can get their STEM extension. So we'll talk about those companies and what the impact of that is going to be. We'll also talk about the issue of people who receive their H-1B, maybe stay here for a few years, and then decide they want to go back to their home country for a certain period of time. How can they get back to the U.S.? How does it work, whether they have an approved I-140 or if they don't have an approved I-140, and is it even possible? Then we are going to talk about EADs. When you have your C9 EAD, that's your GC EAD, what happens in that situation if you're the main applicant and you lose your job? How can you deal with that situation? How do you make sure that your green card process can continue when you are in that situation? And then lastly, the countdown to your H-1B 6-year limit. Nowadays, it's really a 2-year countdown to make sure you can get your I-140 approved in time. So we'll talk about what that process and timeline looks like. So first, we have these, we already had Integra Technologies, AZ, something or other, Wire Class. There's Apex we talked about a few weeks ago. Now we have even more companies that are
Yes, Emily, there are more companies that we are seeing. These people from India that operated the Apex, that operated the Integra, and more people are coming into it, and we find more victims in USA using these people's services to obtain the employment OPT letters. Typically, how it works out, Emily, is these people are running out of time because they know that if they don't provide an employer letter within the 90 days, more than 90 days of unemployment at the OPT period, they will be kicked out of the civil system because 90 days is the maximum limit. So they do go to these kind of employers and pay the money to obtain the immigration letters, employment letters. So initially they say they are for training and they deceive these people, but actually there is no training involved. They take the money. These people are operating from India. Now, a lot of these people, a lot of these victims, they are under the belief that since the company is an E-verified company, though, they must be in good standing. They must be a good company. That's the only thing that I see commonly, people asking the question, hey, it's an E-verified company. How can I not trust this company, though? And these people actually are operating from India. They're not even operating from United States. There are some common characteristics I can tell about these fraudulent companies so that people don't fall into the victim. If they're asking you money to provide the employment letter, it is fraud. Do not touch that company. Don't go near the company, though. Also, try to verify if this company exists physically. You should visit the office once. That is the best thing that I would recommend to do it. If you cannot even visit the office, though, at least Google it to find out if it's not a barber shop or a massage parlor or something else. And all these companies, they operate from a PO boxes where in one address, though, there are like 600 companies' addresses are there within that small 300 square feet or 500 square feet office. 500 companies are there. One of these companies is this one. And these people also, they charge money to sign the I-983, which is required for the STEM extension, as you know, Emily. So our guys are falling into victim. They're only trying to look into the victims are only trying to look into the temporary gain so that they don't fall out of status, but they're not looking into it that they will have a lifetime ban to getting involved in this company, to collaborating and conspiring to defraud immigration by getting the employment letters by paying the money. So I see a lot of people's lifelong affected. What I tell people is that if you don't get an employment, go back to school if you want to, go back to India if you want to, but don't get involved with these companies. So you will have a lifetime ban if you get involved with these companies. Don't get into this. Any other advices, common things that you see, Emily, from these fraudulent companies?
Yeah, and I would, suggest that if you are getting close to that 90-day unemployment limit, remember there are options for training. There's options for OPT employment. You can volunteer. It can be unpaid training as long as it's related to your major. It can be part-time. Go back to your school, ask a professor, hey, do you need some help with a research project for 20 hours per week? I'll do it for free for the next couple of months. While you do that, then you can be looking for your paid job. So there are definitely other options available than falling into these traps and taking the easy way out and paying for a letter or paying for someone to sign the 983 form. Just avoid all of that. And again, as Raul said, Google the company, Google the address. A lot of times we find it's a FedEx store or a PO box virtual address. If they don't have a brick and mortar location, that's definitely a problem. And if you've never actually talked to these people on the phone or in person, that's also a red flag as well. If they're only communicating to you on WhatsApp, if you're only heard about them from a friend of a friend of a friend, you've got to do your due diligence, dig into it, and make sure it's legitimate before you proceed. And if they're asking you for money, it is not legitimate. There's no company out there that's going to be asking you for money in exchange for an offer letter.
Emily, with regards to the H-1B, a lot of people are under the belief that if I get an H-1B and if I don't have a job, if I have to leave the country, I have to get back within the H-1B limit. Let's say, for example, I filed an H-1B and it's valid until 2026. And I only used up 1 year of H-1B and now I don't have a job. I want to go to my home country. Can I only come back within 2026? Or is it up to 6 years from the time the H-1B has been approved? What is the time limit where I can come back to USA on H-1B without subject to the cap?
There isn't one. So it's not the end of your I-797 approval notice. It's not the end of your 6-year limit from when you started H-1B. If you have any time left towards your 6-year limit, you can recapture that time anytime in the future. There's no restriction on that. And that's based on a 2017 regulation that kind of changed how they look at that. So it's very clear in the regulations. You can go back to your home country, wait 10 years, and any company in the US can sponsor you 10 years from now, 20 years from now for an H-1B without going through the lottery. Has to be consular processing because you're outside the US. That just means that your approval notice will come with no I-94 attached to it. So you'll have to go for a new visa stamp in your passport once you get the approval, and then you come back into the US. And whatever time you have left towards your 6-year limit, that's what amount of time you can get on this H-1B 10, 20 years from now. And if you have already hit your 6-year limit, but you have an approved I-140, as long as your I-140's priority date is not current, you can do the same thing and get a 3-year H-1B to come back anytime in the future. But for that, your priority date has to be not current.
Even if it's current, Emily, if there are circumstances where we can show that why he didn't file the 485 application, we will be getting the 1-year extension of the H-1B instead of 3 years. So that definitely is an exemption that's available, and mostly the priority dates are not moving. So there is no time limit for you when to use the H-1B, when you can come back. Now, where did this concept that you have to get it within 6 years of the H-1B came in? When did it change, Emily?
Yeah, so prior to 2017, the way the question on the form was written, it asked, have you ever been granted H-1B status within the last 6 years or something to that effect? And so that made it seem like you could only do this if your H-1B was granted within the last 6 years. So you have your 6-year period. Once it's gone, even if you didn't use all of those 6 years. But the regulation that came out in January 2017 changed that. It took off that time restriction and said anytime in the future you can recapture any unused H-1B time without having to go through the lottery.
Emily, you said that you can use this up to 90 years in your article, and then you said that I have to go to the consular processing and get the stamping and without going subject to the lottery, and you put the conditions though. But what if I move to F1 or I move to H4 visa and I want to convert back into H1B at a later date? Can I do it after 7 years Now I'm an H4 visa for 7 years. Can I convert back to H1B without going to the lottery system? And do I have to go outside the country to get the stamping?
Yes, you can do that as well. So you can file a change of status back to H1B, assuming you're maintaining new status you've been in for the last few years, and you can recapture whatever time you didn't use in H1B status. So in that situation, you don't have to go through the lottery, but you also don't have to go for stamping because you're in the US maintaining status. You can qualify for a change of status. And once that's approved, then if you later decide to travel, that's when you're going to need to get a new visa stamp because your previous H-1B stamp would have expired likely by then. But yeah, so it can be done if you're staying in the US, whether it's F1 status, H4 status, any other type of visa that doesn't count towards your 6-year limit.
And also for those people who are completing the 6 years limit and there is no labor certification available right now or perm file right now, the better solution for you is that even when you are in India, you can still file the labor certification. Even if you're not working for that company, they can still file a labor certification and they can still get an I-140. And if they get an I-140 though, you don't have to go to the lottery system. You can come back to United States using your old almost completed 6 years of H-1B previously. Based on the I-140, you can get a fresh 3 years of H-1B without going through the lottery system. The problem is that you should try to avoid the lottery system at all costs. You need to try to do whatever you can to avoid the lottery system. The reason is that if you go to the lottery system, you already know that you have to apply in March, and you are going to get a H-1B approval starting with October 1st. That's not the only minus point. There is another minus point. You have less than 1/5 chance of getting into the lottery system. That was until the previous statistics. Now things are changing. There are many applicants that are coming in. It may be 1/6 or 1/10th chance that you will be getting through the lottery. So one, the employer has to wait from March to October. Second, the employer is under the belief that it's going to be only 1/5 chance. So they may not want to pick you as an option. So you should try to do everything you can to avoid the going through the lottery system.
All right. Let's say that I have my I-485 filed, it's pending, and I got my EAD. Based on that, I'm the main applicant, and I've been working on my EAD. I let my H-1B expire or my L-1 expire, and then I lose my job. What are the options there? Do I get the 60-day grace period to find a new job?
No, Emily, there is no 60-day grace period for the adjustment of status. At all costs, people should try to save the adjustment of status. There are two aspects here. There's one H-1B and there is one adjustment of status. The rule of the H-1B is that between the two jobs, you can have a 60-day gap period. It's perfectly allowed. They say it's a discretion, but almost every officer will approve the change of employer. That is for the H-1B. When it comes to the adjustment of status, there is no rule such as a 60-day grace period. It is not clear how the officer will interpret it. I strongly recommend that you have as minimum as gap as possible between the two employments. So a lot of people ask, how come I have an EAD, I cannot just stay in this country? Well, not technically though. We'll discuss more thoroughly on that later on though. So the 60-day rule is not applicable in the adjustment of status. It's as simple as this, guys. There is called cricket, and there is called soccer, which is called football. The LBW rule, for example, for you, what is applicable in the cricket is not applicable in the soccer or football. It's completely different. So don't use that same 60-day rule into the adjustment of status. Now, coming to the adjustment of status, Emily, what are the other alternatives? If I don't find the job immediately, what are the other alternatives? Of course, finding a job immediately, joining another job is the best option within the similar field. Emily, what are the other options available for me?
Yeah, besides finding another job that's similar so that you can qualify for AC-21, AC-21 does allow for self-employment as well. So you could potentially, since you have an EAD, you're authorized to work, you could start your own company that's in the similar field, using your same qualifications that were on your labor certification. and you can use your own company and work in that and have that company now basically become the sponsor of your 485. Your company can file the I-485 Supplement J and fill that out. We would recommend definitely making sure the company takes all of the appropriate action so that it is up and running and a legitimate company. But that is an option that we've used in a few cases, even cases that had interviews with USCIS officers, and that's been successful because they made sure that all of the company was up and running, ready to go. They had a website, they had the tax ID number, they had the bank account, they had a lease for their office space, and they could show that they've been paying bills and receiving income through the company bank account. So that would be one other option. And then same thing if the spouse also has the EAD, the spouse could be the one to start the company and potentially hire the main applicant as the to use AC-21.
There are some other risky options of having a job offer but not doing the job. Definitely, I would consult an immigration lawyer privately if you want to explore those options. So these are, getting job definitely is the best option that's available. Does the job has to have the same salary? Doesn't have to have the same salary. Can you go down on the salary by a certain percentage? Absolutely. We don't see that as a problem though. But yeah, getting job is first priority. All other alternatives, we strongly recommend that you discuss those options with an immigration lawyer. Emily, going to the countdown begins last 2 years of the H-1B. Now, I'm lazy or my company did not offer the green card application. I'm just working for that company, and now it's only 2 years left right now. What are the solutions if my company is not sponsoring the green card?
It may be time to look for a different company that is willing to sponsor the green card immediately when you join. You could also potentially look to have another company sponsor you while you stay with your existing company. We refer to that as kind of future employment, because the entire labor certification I-140 and I-485 isn't necessarily based on your current job that you have today. It's based on an offer of employment for a job that you will take when you get your green card. Like, companies can actually sponsor people for a green card who are not even in the United States. So it doesn't necessarily have to be a company that you're working for today. So you can look for another company that may be willing to sponsor you as long as you join in the future when you get your green card. Another thing to look into is the self-petition options, NIW, National Interest Waiver. If you are in a STEM field or AI or any kind of critical emerging technology, the Biden administration has come out and said, yeah, we want to promote that. So we're going to approve NIW cases for people much more easier than they had in the past. So with NIW, basically, it's a national interest waiver. You're telling the government, because the work I am going to do is in the national interest, I want you to waive the labor certification and the requirement that I have an offer of employment. That means you skip the entire labor certification and go straight to filing your own I-140 yourself, showing that you meet all of the qualifications for that. And you can do that relatively quickly, and you can do premium processing. You can get it approved yourself, and then you can keep extending your H-1B based on that. The other self-petition option is the EB-1A. Definitely harder to qualify for, but again, the Biden administration has opened that up to STEM, to AI, to emerging technology, so it may be a little easier than in the past to get those approved.
And we recommend a lot of people who have been getting jobs now and who are not filed the labor certification, first labor certification, I-140, we strongly recommend don't wait. Pick as soon as possible. Even if you have a doubt that you're going to leave the company soon, try it. Who knows? You may change your mind. And it may be better for you to get an I-140 approval, because otherwise 6 years just passes just like that. Believe me, guys, we've been in this business for a long, long period of time, and people come to us in 5 years, 11 months, and 20 days. They come to us, Rahul, how do I get this thing over? It becomes hard for us to give any solutions for them. But if you try to come before 2 years, though, There are some innovative solutions that you can think, joining another company, having an offer from a different company, looking for opportunities elsewhere, or probably trying to spend some time outside the country. So these are all the options. H4, if you have an option of H4 EAD, definitely take that option too. Let's go to the Q&A assembly.
All right.
Daya Sagar has this very good question from the YouTube. Can you go back to India after EB1C I-140 approved and come back later on when it becomes current? Yes, you can. But should we have the job offer from the same company to get the green card later on? Yes, it has to be from the same company. EB1C has to be from the same company. If you get a job offer from a different company, you may not be eligible for EB1C unless the new company, you're also going to file an I-140 under EB1C, which is very tough to look into. But yeah, you must have the same job offer from the same company.
Himanshu wants to know how many applications we're expecting for this year's H-1B lottery. That's definitely a good question. You know, I think that there are a couple of things that make it difficult. Number one is the online system is changing. So that might bring things back to where they were in 2020, maybe 2019. At that point, I think we had around, if I can read my notes, 231,000 to 275,000 in that range, because we're not going to be getting those duplicates and all those fraud companies filing. I do think it's going to be more than that because we have continued you know, backlog from the people in prior years who got their master's degree and have their OPT. First year didn't get selected, second year didn't get selected. Now they're in their third year. So those people keep stacking up. So I don't know. I'm thinking maybe 300, 400,000.
Yeah, that's what I'm thinking, Emily. Between 300,000 to 400,000. Also, there has been a lot of influx of F1 visas from India in the past 3-4 years. These people have graduated. India has overtaken China as the #1 student population, foreign student population in United States in 2022. So all these things will contribute to the oversubscription of the H-1B. So yeah, between 300 and 400,000 is what I'm expecting.
Prashant says, me and my family have the GC EAD and AP, and I also have an H-1B. Can I remain on H-1B while my family moves to the EAD? Yes, that is possible. The family is not dependent on you. If you're staying on H-1B, they can choose to remain on H-4, or they can use the GC EAD because it's a lot easier if something goes wrong for them to get back to H-4 because you've continued on your H-1B. The one caveat would be if you have older kids who may be at risk of aging out, whose age is not actually locked in yet, they may need to stay on H-4 so that they have the opportunity to file a change of status to F1 once they turn 21.
Ravuri Chowdhury has this question that his grad date is 2016. Should he consider EB-5? Definitely, he should consider EB-5. Recently, we had a chat with Charlie Obiham, the State Department gentleman who used to operate, who used to control the visa numbers. He said by the time it's going to cross the January of 2015, it may take anywhere between 5 years to 7 years, though. Yeah, you should definitely consider EB-5. We have a link at the bottom to evaluate whether you will fit into it. There's a free consultation our office provides for those people who are contemplating and filing an EB-5 application. The link is there at the bottom. You can just fill it out, and then you will get a free consultation from our office for EB-5 considerations only. Now, this is only for EB-5, not for all other cases, guys.
Kumar says, I work for 2 employers on a concurrent H-1B, and I received a notice for a 485 interview for next month. Do I need to tell the officer about the other employer who's not listed on my 485 application? So you don't need to proactively tell them because you're not filling out your employment history when you're going for your interview. If they ask you to provide your past 5 years of employment history, absolutely, yes, you need to provide that information. If they ask you, who's your employer right now? yes, you say I work for this company, but I also work for this company. So yes, if they're asking you what your current employment situation is or asking you for your employment history since you filed the 485, you do need to provide that information. I will say that officers tend to be a bit confused about people working 2 jobs. Apparently, they've never heard of that before, even though there's plenty of people that do that in the
because
U.S.
they are the government employees, Emily. They are the lazy.
They don't need to, or don't. Yeah. So if you are going for the interview, I would recommend getting an employment verification letter from both companies. Make sure you bring your H-1B approval notices for both companies, bring recent paychecks for both companies, your pay statements, and bring your W-2s from both companies, and just be prepared to explain how it is you work for 2 companies at once. Maybe you work, Monday through Friday for company A, and then on the weekends you work for company B part-time, or maybe in the evenings, whatever it is. Even if it's 2 jobs for 80 hours a week, that's totally fine. All of it's allowed, but just be prepared to answer questions because the officer might be confused.
Arindam has this question with regards to whether he's eligible for EB-1A application. A couple of things. What he said is that he is working for a multinational company. No, that's nothing great. You're working as a technical leader. That may work out to be one of the criteria for the EB-1A. That you have 23 years experience, that's not relevant at all. Whether you have 1 year experience or 10 years experience or 50 years experience, that's not one of the criteria for the EB-1A. But looks like you work for AI and you are in a critical position. You should evaluate yourself, and the particular lawyer in our office is Kareem Jivani, and you can get the evaluation done. Even if you're not eligible, you can check whether he's eligible for the 3rd criteria. You can check whether you're eligible for these criteria or not. And if you're not eligible, he will give you a guidance in future for you to be eligible for EB-1A. What are the steps you need to take so that in future you will get an EB-1A approval? You're highly likely to get an EB-1A approval.
Nihal wants to know, can I travel out of the U.S. while my H-1B amendment is pending for a location change? My general rule is don't travel while you've got an H-1B pending. If you don't need to go for stamping, it's a little bit better. But what's going to happen when you go out and come back in, you're going to get a new I-94 number when you re-enter, and then your amendment is going to be pending, and it had your old I-94 number on it, and your approval notice is going to come with your old I-94 number. That can cause an issue sometimes when you go to get your driver's license in your new location. Anything that you have to do with the Social Security office, they get confused because there's a mismatch in your I-94 numbers. That can be cleared up if after you get your amendment approved, you travel one more time, maybe do a margarita switch going to Mexico for a weekend and coming back in. That will get you another new I-94 number. Then everything is clear. But if you're going for stamping, definitely don't travel until that amendment is approved.
What's the fees for the NIW for the I-140? No, we don't give out the fees out in this YouTube, guys. It will depend on if somebody's clearly qualified and everything is telling that it's going to be approved, the fees will be different than compared to when we have to get a lot of recommendation letters and a lot of work, then it will be different. Sirisha Kulkarni has this question. Can I go from EB3 to EB1 directly? Yeah, absolutely. There is no requirement that you have to go to EB2 before you go to EB1. Absolutely not required.
Krishna says, do we have premium processing option to convert from H-1B to H-4 and H-4 EAD? Not for a standalone change of status to H-4 plus an EAD. If you're just filing an I-539 and I-765, there's no premium option, and those are taking several months. However, if the H-1B spouse that has the approved I-140, if their employer is willing to file something like an amendment of the H-1B, then you can include the H-4 and the H-4 EAD along with it and file that in premium. Everything should get approved in premium processing if you do it that way. So it's kind of a backdoor way to still get premium processing, but it requires the employer to play along.
Geetika IDS has this question. She wants to know about the O1 requirements, please. My son is in second year undergrad. We don't want to be in the H1 loop. I'm a bit confused. I'm assuming that you already have a H1B. If you already have an H1B, there's no need for you to move to the O1. Definitely, if you are not having an H1B, you should consider the O1 requirements. It's very tough to explain all the O1 requirements in this Q&A. We may do an O1 session separately. If we have not already done it, we'll do a O1 session separately on it.
Dia says, I have a cap-exempt H-1B expiring in May, and my 6 years will be complete in this status. I also have an approved I-140. Can I switch to a capped subject or a for-profit employer? The only way to do that is to be selected in the lottery. So if you are selected in the lottery and your company files an H-1B, the for-profit employer, you can rely on your approved I-140 to get a 3-year H-1B with that for-profit employer, assuming your priority date's not current. But you'll have a gap from May 2024 till October 1st, 2024, where you will not be able to work for any employer because you'll run out of your H-1B time with the cap-exempt company.
My bad. Sirisha is saying that it's not EB3, it is E3. You know, I'm in the Indian mode and seeing when I see E3, I only look into EB3. Can I move from, what she's asking is, can I move from E3 visa, which is for Australian citizens? It's a non-immigrant visa. Can that person move to EB1? Well, depending on where you're born, for example, if you're born in India, you may want to have a consultation with an immigration lawyer. The reason is that the priority dates don't move that fast. And there are chances that your E3 extension may be denied because you filed an EB1 though. Now, if you're born in Australia, it's completely different because you fall into the other national criteria. It's probably easier for you to get an EB1A approved in premium processing and file the adjustment of status. Definitely that would be it. But if you're born in India, though, even though you have an Australian passport, for the purpose of the green card, you will be considered to be in the line of Indians, not in the line of Australians. Although when it comes to the E3 non-immigrant visa status, you're considered to be Australian citizen. When it comes to the EB1A, you will be considered as Indian nationals. Why there is a problem, the difference between an E3 and a H1 is because E3 must have an intent to temporarily stay in the United States. H1B and L1, on the contrary, can have an intention to permanently stay in the United States, and their H1 and L1 will still be extended. But that may not be true in E3. That's the reason I'm telling you to consult an immigration lawyer before you go and file an I-140 in EB1A category.
As you file mandamus lawsuit for delayed I-485s? Yes, we do. Stephen Brown in our office handles. You can email him directly to find out the cost and the timeline for it. His email is steven@rnlawgroup.com, or you can always email info@rnlawgroup.com and we'll get you in touch with him.
Can I travel internationally when EB1A advanced parole is still under process? Depending on, I'm assuming that if you are an L1 visa, which is valid, if you are an H1B, which is valid, and you are going for stamping or you already have a stamping, either L1A, L1B, or L2, or H1B or H4, and you already have those extensions or the validity period, either you have the stamping or you're going for stamping, it is not a problem for the EB1 adjustment of status. So your advanced parole may be denied, but it will not cause any problem whatsoever at all for your 485 application, only if you belong to the non-immigrant visas, which I listed. If you belong to any other non-immigrant visas, then definitely consult a lawyer before you travel outside the country.
A. Kumar filed the AP renewal back in June last year, and it's still pending. And the passport that was submitted with it is now expired, and he wants to know if that's going to be a problem when they actually adjudicate the advanced parole. No, it won't be. As long as it was valid at the time you filed and you renewed it timely, you shouldn't have any problems with the advanced parole approval. And you mentioned that your EAD is due for renewal now. Can you just reapply for the advanced parole? Yes, you can. We've done that a number of times because the APs have just taken forever. And so we just included another one when we did the EAD renewal in the hopes of getting the combo card valid for 5 years. And we are seeing, we still have some APs that were filed last February and March 2023 that are just now getting approved. So the processing times are ridiculous on that.
Who's the contact person for the O1 visas in our office? There are 2 people, Rebecca Chen and Karim Jivani. These are the 2 people who are good in O1 visas. UK is asking this question: how safe it is to go for H1B stamping at consulate without being on the project, even though I am getting paid by the company? Suicide. That is considered to be suicidal. Definitely one-way ticket. Don't do that.
Zorowar says, premium processing for EB1C I-140. Is it advisable? Are there any pitfalls of filing in premium? I'm generally a fan of premium processing for anything but EB1s, at least EB1C, I'll put it that way. I've just seen some really silly RFEs and just a waste of time kind of RFEs on that. So I usually don't file those in premium processing. I've upgraded a few recently and immediately got an RFE on it. So yeah, I'm not a huge fan yet.
Ricky, I recently received my GC. Will I face any problem if I'm entering after 5 months outside the United States? Make sure it is under 180 days. If it's under 180 days, though, you should not face any problems. If it's more than 180 days, definitely consult an immigration lawyer.
Vinod Kumar says, can the H4 continue to stay in the U.S. when the H1B is in the 60-day grace period? Yes, you can. The 60-day grace period is considered to be that the H1B holder is in valid H1B status, which means the family members are considered to be in valid H4 status during that time.
Viraj is saying, I'm planning to go for H1B stamping in India to August. If I get to 221G India, can I travel back in advance parole? I want to get stamped and only use AP as a backup. Yes, you can, but there are certain circumstances where the consulate can give you trouble, where they may even give some problems to the advance parole also. Very rarely we do see that. Very rarely we do see that. But mostly people will be allowed, even if you get the 221G, you can come back into the United States on an advance parole. Now, one caution, one recommendation is that why do you need to go for stamping? You can come back on advance parole and extend the H1B if you want to, transfer the H1B if you want to, amend the H1B if you want to. It's just my precautionary thing, saying try to avoid going to the consulate. You just don't want to put your head in a lion's mouth and see if it bites. Try to avoid it if you can.
Sri says, I'm on STEM OPT working for a company right now, and if I get my H1B from this company, do I have to still be with them until October, or is there a chance to change the company and file a transfer before October? Filing a transfer before October can be a risk because USCIS might say, because your H-1B hasn't actually started yet, you have not actually been counted in the cap, even though you were selected in the lottery, even though you filed the H-1B and got the receipt, even though you got the approval. Because it has not taken effect yet, they can say that you have not been counted in the cap, therefore you're not eligible to transfer. So we generally recommend waiting until October 1st to file an H-1B transfer. Unless you're in a job loss situation where you don't have a choice, then it might be worth it to take the risk or decide whether it's better to have them withdraw the H-1B and stick with your STEM OPT. That also has its complications because USCIS takes forever to process the withdrawal. And if it doesn't get withdrawn before October 1st, they'll just cancel your service record. And then you have trouble with your F1 status. So there's lots of issues with that. I do have a blog post at immigrationgirl.com about that if you want to check that out there.
Can H-1B holders allowed to do itemized tax filing? Yes, you can. Absolutely not a problem.
Aishanoy says, I was never counted in the cap. I have an approved I-140. How can I switch to a for-profit company now? So having the approved I-140 doesn't make you cap exempt. It just makes you exempt from the 6-year limit. You can keep extending your H-1B beyond 6 years, but to switch over to for-profit, the only way to do it is to go through the lottery, get selected, and have the petition filed and approved.
Sudha Yanamanda has this question. I'm born in UK, Indian parents, 22-year-olds, undergraduate degree, graduating in May. I'm working in a pediatric clinic part-time. Can I apply for EB3 and NIW through the employer? Well, you can definitely, but the question is that based on your, that you're graduating, that you're working in pediatric clinic does not automatically make you qualify for EB3 or for the national interest waiver. The position must require at least 2 years of experience to be qualified for EB3. Now, there are certain things that need to be considered for EB3 with national interest waiver. The bar is a little bit higher. So you need to, if you are qualified and employer is qualified for it, yes, you can file an EB3 or national interest waiver. But the fact that you're just working with pediatric clinic does not automatically make you eligible for either EB3 or national interest waiver.
Nailesh says, if my perm is in process and in the meantime I complete my 6 years of H-1B, what are my options to stay in the US or come back again if I need to leave? So first I would look at, was your perm filed at least 365 days before the day you hit your 6-year limit? If it was, then you're actually eligible for a 1-year extension, a 7th-year extension of your H-1B. I'm assuming that's not the case and your perm wasn't filed until you were already in your 6th year. Then you look at, can I take some strategic vacations or strategic trips outside the US to be able to recapture enough time to allow my 6-year limit to be extended out so that my perm will meet the 365-day rule and I can get the 7th-year extension. If that's not an option, maybe change status to H4 temporarily. If that's not an option, maybe change status to B2 temporarily, and then come back to H-1B, file a change of status back to H-1B when either your perm has been pending for 365 days or your I-140 is approved.
Zoref has this question. I'm visiting Canada without the H-1B stamping using an automatic revalidation. Is going for 2 weeks. What documents beside I-797 you should carry? You can take the pay stubs, W-2 forms, and bank statements, but don't show it to them. Don't confuse them. Just show the H-1B approval. If they ask any questions, are you really employed with this ABC company that you have an H-1B? Then if they ask more questions about it, can you show the pay stubs? You show them. Just take the H-1B approval, rest of the documents, the pay stubs, W-2 forms, income tax returns, bank statements, put it as a backup in a package. Don't show it to them. If they ask, you show it to them.
Binod says, do we need the H-4 EAD approval to continue the job, or just the H-4 EAD filing is required for an H-4 EAD renewal? The H-4 EAD filing by itself does not give you the automatic 180-day extension of your EAD. What you need to get the automatic extension based on having a pending H-4 EAD is to get your H-4 extended beyond the current validity date. So what we had a lot of people do when we were seeing all of these delays happening is we would have the H-1B holder file the renewal as early as possible. Once the H-1B holder's status had been extended, then have the H-4 travel outside the US and come back in using automatic revalidation before their H-4 expires, but showing the extended H-1B approval notice. Many times, most of the time, they were able to get an I-94 for H-4 status that's in line with the new H-1B approval end date. So they're getting the H-4 status extended through travel, and then that provides them the extended I-94 that they need to qualify for the automatic EAD extension for 180 days.
What is the requirement for advance parole for re-entry into United States? Can I re-enter only 1 day before the advance parole expires? Yes, you can, absolutely not a problem. However, I just want you to do it at least 3 or 4 days before. The reason is that what if the flight gets delayed? What if you go to Turkey and the flight fails and you have to come back and you can't come back? That's the fear that I have. Then you can't come back in advance parole because advance parole expired. But yeah, 3 days, 4 days before, that's perfectly all right, not a problem. They won't question, hey, your advance parole is only expiring in 3 or 4 days. They will not create any problem in your entry to this country.
Batman says, can my employer withdraw my petition if I exit the U.S. right after my I-140 is approved and not wait the 180 days? And then would it be possible to come back in the future using that same I-140? The employer can withdraw at any time. So if they withdraw less than 180 days after the approval, that means you cannot use that I-140 approval to extend your H-1B further if you're already beyond the 6-year limit. So that is a big risk. It's definitely, if that's your very first I-140, you need to wait 180 days and make sure your employer doesn't withdraw before 180 days.
Anthony Brown has this question. Can one switch companies, job roles with an EAD when 485 is pending for 300 days under EB1C? What are the implications? First thing, I'm assuming that the I-140 is already approved, assuming that. Can you switch the companies? Absolutely. Job roles. Now, job should be in a similar category, like higher level executive position. But does every job duty that you have done previously has to match with the new job duty? No, but it should be in a similar profession, in similar hierarchy of the position, because it's an EB1C, then you're perfectly all right to change the job, to change a different company.
A. Kumar says, is there any requirement as to how long before the AP expiration one should travel back to the US? You already got that one?
Yeah, I just answered. Questions with regards to the H4 EAD. Those people who are in H4 EAD, can they do the stock trading? Yes. Can they do business? Yes. Can they open companies? Yes. They can do any legitimate business on H4 EAD. Can they work for multiple employees? Yes. Do they need the permission from USCIS to work for multiple employees? No. So H4 EADs have a lot more flexibility, guys.
Sri says, do we need to stay with the employer for 6 months after getting the green card? No, there's no requirement to stay with the employer for 6 months after getting the green card. The whole basis of the green card is an offer of employment that the employer intends to give to you when you get your green card, and you intend to accept it when you get your green card. But the law also requires you to leave that employer even before you get the green card under AC 21. So why would they then require you to stay with the company for an extra 6 months after you get the green card? There's no such requirement.
Can I port the date from EB1C to EB2 because I'm moving from L1A to H1B? I lost the job in L1A, but I'm moving to H1B. Can I port the EB1C to EB2 at a later date? Yes, you can port the date from EB1C to EB2. Not a problem. You can port from EB2 to EB1, but vice versa also you can.
Srinivas says, I have my 485 in EB2 and EB3. I got my EAD and AP approved based on the EB3 485. Can my wife file the EAD and AP renewal based on the EB2 485? Does that cause any issues? No issues at all. The whole reason both of you are eligible for EAD and AP is because you have any pending 485. It doesn't matter which category it's in. So just pick one and use that to file your EAD AP renewal.
Birendra has this question. When will the priority date will be for the green card? Is it when we file the I-140 or POM application? The priority date is established on the day you file the POM application. However, it's not confirmed to you yet, though. It will only be confirmed after the I-140 is approved. That means, let's say, for example, you file a perm application and then you don't proceed with the I-140 approval, then that priority date is not confirmed to you. But if you file a perm application, later on you get an I-140 approval, the priority date is on the day you file the perm application, not on the day you got an I-140 application filed, not on the day that you got the I-140 approval.
Darshan says, do I have to get the new perm and I-140 from my new employer before applying for the H-1B extension? So I'm assuming you have an approved I-140 with company A, you filed a transfer to company B, and now you want to file your extension with company B and want to know if you need company B's I-140 to be approved to do that. And the answer is no, as long as company A's I-140 was approved for at least 180 days, and if they withdrew it, or if they didn't withdraw it, then you're fine. You can use company A's approved I-140 and keep using it to keep getting H-1B extensions with any company until your priority date becomes current. At that point, that's when you need the new perm and I-140 to be able to actually file the I-485.
I'm in my last year of L1B with an approved I-140. Is there any way to extend the stay? H-1B processing for last 4 years haven't been picked up. Well, of course, you already know that you will try one more year of the H-1B. That's you already know. If that doesn't work out, though, you may have to leave the country and keep applying in the H-1B lottery, or come back on L1B later on after 1 year of your stay outside the country. Or if you're eligible for L1A, that's one thing that you can consider, that if you're eligible for L1A right now, you can convert your L1B into L1A. And as you know that L1B is only for 5 years, L1A is for 7 years, so you can extend it by 2 more years.
Kumari says, I'm on H-1B with a company for over 10 years, got my GCEAD, never used it, and now it's expired. Do I still need to renew my GCEAD and AP in case I'm laid off on H-1B? Do you need to? Technically, no. Should you? Absolutely, yes. Because you never know, you can't predict the future. You might get laid off, or you might decide to quit. And if you don't have the EAD, you need to make sure that your new employer is willing to file an H-1B transfer within 60 days. If they're not, then you could be in trouble. So definitely we recommend always having an EAD and AP valid, even if you don't use it. They're free. There's no filing fee for it. So go ahead and get it. Keep it that way. You can always travel. You can always work in case something goes wrong with the H-1B.
Yahoo Me has filed an EAD and AP renewal. The receipt notice have incorrect priority date. Absolutely not a problem. It's not going to create any problem, none whatsoever at all. Also got biometric reuse notice with the case numbers with I-131, I-765, but did not get an AP receipt notice. Is it okay? Did not get AP receipt notice. That's a little bit confusing. What do you mean you did not get the AP receipt notice? So I am a bit worried about that. You can call the USCIS to see if they will give the receipt notice of the I-131. If they don't, I may want to just refile the I-131 again. Right now it's free. On April 1st, the fees is going up. So I would file an advance parole right now without any problem. Just in case if you didn't receive a receipt notice and you call the USCIS, they don't give you the receipt notice.
Cheng Liao says, how to lock in the H-1B remaining dates if the status changes. I'm assuming, let's say you stayed on E for 5 years and now you filed a change of status to F1. Then you later want to switch back to H-1B. Once your F1 change of status is approved and takes effect, you're no longer counting H-1B time. So anytime from that point going forward, you can recapture when you file your change of status back to H-1B. So it's based on the approval of whatever status you've changed to and the effective date of that change of status.
Can someone renew his green card after 10 years, even if somebody stay out on re-entry permit for 8 to 10 years? Yeah, when you apply for the green card renewal, they don't look into all those details. So all they look into is that if you have any criminal convictions, That's all they look into. So yes, you can file for green card renewal. I'm not expecting any problem. But all those states, you did it with the re-entry permit, so you should be fine.
Jagadish says, my advanced parole is pending since November 2022 at the Texas Service Center. What can we do at this point to get it approved? File a lawsuit tomorrow. Definitely. That is ridiculous. We don't have any pending that long as far as I know. So definitely file a lawsuit. You can reach out to our team, info@rnlawgroup.com, or Stephen Brown, Stephen@rnlawgroup.com as well, to get information on that.
Himanshu says this form was applied in 2012. It went to Balka. Later, I switched to another company and got I-140 approval. Can the old date be reviewed if employer agrees? I'm assuming that you never got the I-140 approval with company A, for which you filed the form in 2012 and went to Balka. If that's the case, though, no. Even if your employer agrees, you cannot retain the priority date of 2012, because for that labor certification, you never got the I-140 approval. You never filed an I-140 for that particular application. Because of that, you cannot retain the priority date. You know, sometimes we need interactions with the people, guys. So Reddy Neumann PCA has 3 different forums for you to ask the questions, and we do give free of service for those things. We do have a daily conference call where we take the written things and then speak with you. And then we have a TV Asia thing every Sunday at 7 p.m. Central Time, where we only take the phone calls. And we do have a Tuesday where we only take the messages and response to it. So we have 3 different forums. One is Sunday, where we only take the phone call. Tuesday, we only take the messages, YouTube and Twitter messages and Facebook messages. And we have a daily conference call every day for half an hour, where we can do both things. We take the written messages and then speak with you to give free advice to you guys. Please utilize our services, and the links are provided there for you, where you can avail the services of the free daily conference call.
Sairam says, my wife's H-4 EAD expires December 4th, and her H-4 also expires on the same date, December 4th. But she got an I-94 until May 2nd of the following year. Until when can she work, and when should she file for the H-4 EAD extension? Well, her H-4 EAD expires December 4th, so that's the last day she can work. Getting an I-94 beyond that does not mean that she can keep working beyond the date on the actual EAD card. Now, I'm assuming she got the I-94 beyond that because maybe you filed a transfer and she entered and provided your H-1B approval notice, so she got that extra time like I talked about earlier. So that's good, because when she does file her EAD renewal, she'll get an auto extension because her I-94 has already been extended. But it will only be till May 2nd, 2025. So, and then when should she file for the H-4 and EAD extension? I would recommend filing for both the H-4 and the H-4 EAD extension right at the 6-month mark, so that she can utilize that automatic extension till May, and hopefully the new card will come in by then. Or if your employer needs to file an H-1B extension or an H-1B amendment for some reason, file them together with that in premium processing, then all 3 can be approved together in premium.
Arun has this question of the day. His priority date is 2012, filed 485 under EB3 in October 2020, then converted into transfer of underlying basis to EB2 in February 2022, then changed the company in June 2022, and employer filed a transfer of underlying basis again in August 2022. Am I in EB2 or EB3? I don't know the answer, but I will tell you this thing, whichever is current. If I were you, I will tell the USCIS I'm in that particular category. If the EB3 is current, I will tell you are in EB3. If EB2 is current, I'll tell you are in EB2. So whichever is current, you are in that particular category, will be my answer. That is my request to the USCIS to adjudicate. We have done that several times. USCIS never objected to it.
All right, well, I think we're out of time for today. Thank you, everyone, for joining. Please don't forget that we do have a newsletter that we send out every Wednesday with all of our articles delivered straight to you, as well as our latest videos. So feel free to sign up for that by going to rnlawgroup.com.
Thank you very much for tuning in.